Hello, and welcome to the DC Bar Pro Bono Center's webinar, Can Your Organization Show Preference for Vaccinated Customers and Clients? I'm Christine Kulamani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. Thank you to my colleague Warren, who's done all of the behind the scenes work to help make this webinar possible. And a tremendous thank you to our presenter, Dr. Nathan Adams, and his law firm Holland Knight. Nate is a partner at Holland Knight, where his work crosses a wide range of industries. Before we get started, I'd like to go over some of the logistics for today's webinar. First, for those of you joining us live, this webinar will be recorded. To access the recording and share it with your friends, please complete the post-webinar survey that we'll email to you. In addition, you have immediate access to the presentation slides in the GoToWebinar control panel on your screen. If you have questions as we go, please send them to us through the questions box in the GoToWebinar control panel. We'll get to as many questions as we can today. With the mechanics of today's webinar done, let's get to business. As the DC region rapidly reopens following unprecedented public safety closures, and half of area residents have received at least one dose of a COVID-19 vaccination, local businesses and nonprofits grapple with how to move forward while balancing employee safety, customer and client safety, and the ability to return to business as usual, requiring workers and customers alike to be vaccinated, as well as incentivizing vaccination, are topics that organizations are thinking about. And with that, I'll hand it over to you, Nate.
Great, well, thank you so much. It's my honor and pleasure to be here. Been a member of the DC Bar now for many years, and I appreciate the opportunity to share a little information with you today. You know, you may have questions at the end of this that we don't get to, and if that happens, you'll find at the end of my presentation my email address. My telephone number is already on the screen, but feel free to contact me separately if need be. We'll try to cover as much material as we can today. We've got a lot of ground to cover. All right, and what we're going to speak about to begin with is just to provide a little bit of background as to what we're going to be talking about today. Most of our time we'll be discussing mandate requiring vaccination, but we will also discuss a little bit about preferential treatment of individuals as well as incentives towards the end of the program. So what drives the interest in this? First off, the locally beginning in 2020, District of Columbia adopted a Protecting Business and Workers from COVID-19 Emergency Amendment Act. That was extended on February 3rd, 2021. And certainly it's been the focus of DC to make sure that employers properly treat workers and, for that matter, patrons. And then beyond that, the federal government has always, as part of the Osha Act, included a general duty clause that requires employers to ensure the workplace is free from recognized hazards that are causing or likely to cause death or serious physical harm to their employees. This is generally referred to as the general duty clause. So besides local law, we have OSHA law as relevant, and then certainly beyond that, we have to be concerned as employers and businesses about the possibility of negligence lawsuits, of which there have been several dozen filed, in particular against the nursing home industry in connection with treatment of residents, but also by former employees, typically alleging that the nursing home did not take adequate steps to protect against the against the COVID-19 virus. And those cases are typically filed as putative class action cases, and there are many of those pending around the country right now. So we also just need to be aware of the possibility of negligence lawsuits as a grounds for being interested in this subject. Interestingly, here's a page from frequently asked questions that OSHA recently put up. And it reminds us of the general duty clause, and specifically indicates to potential employees who would read it that your employer must provide a workplace free of known health and safety hazards, and then advises the employee as to what to do if they believe that has not happened. And among the rights that employee has is to file a whistleblower protection complaint. You see that towards the bottom of the facts section. So OSHA is certainly aware of the applicability of the general clause for purposes of COVID-19. And then just yesterday, the mayor sent out notice to the DC Chamber of Commerce, and you'll see there one paragraph highlighted in that letter, which said, please help us do all you can to get your families, team members, and customers vaccinated. The use of the term team members rather than employees, I suppose, is a little bit more of an ambiguous term, but again, the request being, hey, do what you can, and then specifically lists a couple resources that might be helpful, and of course, leaves it to you all to determine in more creative ways how you might go about achieving the objective of vaccinating those folks. So let's begin talking a little bit about employees. And on the screen now, you'll see laws that bear upon employee vaccination. And we're going to begin with the one that is probably consuming the most attention online at this point, and that is emergency use authorization and what it means. Emergency use authorization is a little bit of a history about it. It came about actually after 9/11 when there was a desire to utilize particular vaccines, and some of them had not been approved for uses that they were wanting to, that the federal government wanted to, in particular the military wanted to use them for. And out of that came this new criteria, this new way to get drugs, devices, and biologic products into the marketplace without formal approval. And that's what's happened here. There have been 3 EUAs by the FDA that have approved the 3 vaccines that are in common usage now. Again, those vaccines have not yet been approved. It's possible they could still be, but at present time, they were issued under EUA, which means that the Secretary of Health and Human Services, based on the research that the companies did and that was overseen by the FDA, concluded that the benefits outweigh the potential risks and essentially issued the EUA authorization for those vaccines. So what does that mean in this context? Well, the first thing that it means is that here's a question that FDA has put up on its facts section page. And the question is, how will vaccine recipients be informed about the benefits and the risks of a vaccine that receives an EUA? And if you yourself have been vaccinated or somebody you know has been, you've probably received in connection with that preceding the vaccination a fact sheet, which tells you the benefits and risks, the extent to which the benefits and risks are unknown, and indicates that, of course, they have the option to accept or to refuse the vaccine. This is required under EUA statutory language, the citation for which is now on your screen. You'll see the language from the statute itself. And what has received the most attention under the EUA authorization in the area of vaccinating employees is this requirement for choice. And specifically, you'll see there it says to be established such conditions on authorization as the Secretary finds appropriate, including conditions designed to ensure that individuals to whom the product is administered are informed of the option to accept or refuse administration of the product, of the consequences, if any, of refusing administration of the product, and of the alternatives that are available. And so folks have been a little bit unclear as to what consequences are meant in that statutory language. If they're exclusively health consequences, then there's nothing about this EUA language that would prohibit an employer from mandating the vaccine. But if consequences here literally could be employment consequences, if they could be other kinds of consequences, for example, access to services and goods, then there would be a question as to whether it would be lawful to mandate the vaccine. Another question that this language raises is, to whom is it directed? It appears clearly to be directed towards manufacturers. Is it also directed to distributors or to others, such as private sector employers? And you'll notice there the language towards the beginning of that section that the statute says that it's for a person who carries out any activity for which the authorization is issued. And so I think pretty clear that that would be relevant to a manufacturer. And then the question becomes, how much further down the line does that extend? We've been thinking that the government would eventually come out with some guidance as to what it believes consequences means. For several months now, we thought when the new administration came in that would be forthcoming. To my knowledge, it has not yet been forthcoming. And so we're still left to wonder what the real meaning of this is, the implications of it is for an employer. There's only one case that is of any help on this, and really it's of not much help at all. A case out of the District of New Mexico where a plaintiff who was an employee of a detention center has sued because the defendant is requiring first responders to receive the vaccine as a condition of employment. That plaintiff sought a TRO, restraining order, against the requirement. He failed. He has not received it. But in the context of the court order, there are some procedural issues. For example, a failure to provide notification that may have been the reason for the failure as much as the merits could have been. And in that case, the court has ordered expedited briefing, and so that actually has been expedited briefing that there's been no ruling on the merits yet. So there's not much that can be drawn from that case. And in any event, it involves a public entity, which is typically subject to constitutional limitations that maybe a private entity would not be. So we don't really, the bottom line is, with respect to EUA authorization, my guess is if you've spoken to an attorney about this recently, they've told you, to the extent you can wait to mandate or choose an alternative, because we don't really know what the meaning of this EUA limitation is, they typically are encouraging clients to just wait and see if there's some further direction that comes out of the federal government or comes out of the courts. And then the other possibility, of course, is that the EUA will go away and replaced with an approval. And I think a lot of, for example, universities and colleges are anticipating that happening before the fall. Well, what has the EEOC said about mandates independent of the FDA? We've just looked at FDA language, and the statute really pertains to HHS, the FDA. What about the EEOC, which, after all, is essentially responsible for enforcing federal employment non-discrimination laws? If you look towards the bottom of this slide, you'll see a statement. This is a direct quote from the EEOC. If an employer requires vaccinations when they are available, how should it respond to an employee who and poses a particular question? Well, notice, if an employer requires vaccination, there could be read into that an assumption that, in fact, an employer could, under some circumstances, require vaccination. So some look at this statement and they say, well, it's evidence that the EEOC, while it has not formally said that mandates are available to employers, it has assumed as much. And there's some argument not only for that in respect to this paragraph, but there are other directions that EEOC has set. For example, administration of the vaccine to an employee is not a medical examination, according to the EEOC. That's an important distinction that's been drawn for purposes of compliance with the ADA. In addition, the EEOC has said that simply requesting proof of receipt of the vaccination is not likely to elicit information about a disability and therefore is not a disability-related inquiry. Again, another important distinction for purposes of compliance with the ADA. So all of these statements would suggest that, at least under some circumstances, the EEOC anticipated a mandate. All right, so now we come to OSHA. We mentioned earlier about the general duty clause that OSHA has. Just within the last few days, OSHA has provided some additional guidance for employers that's I think very important. And now, of course, this act applies to employers who have more than 10 employees for at least one day during the calendar year, and therefore must maintain what's called the OSHA 300 log. And what OSHA has said here very recently is that if you require your employees to be vaccinated as a condition of employment, then if that employee has an adverse reaction that is work related and certain information may have to be reported on the OSHA 300 log, for example, to the extent that employee misses days from work, is restricted work or transferred to another job, or other factors, medical treatment beyond first aid. So that applies in the event the employer were to require vaccination. OSHA goes on to say that if, on the other hand, the employer merely recommends it, then there is not a requirement for the employer to report on the OSHA 300 log if the employee thereafter suffers an adverse effect. Interestingly, OSHA says, by the way, it's not that that is not a reportable event, because it would be, but we are exercising our enforcement discretion, OSHA says, to make a very clear, bright line here between what is reportable and what is not. So in effect, OSHA, with this very recent statement, does seem to, by virtue of this action, want to channel the employers towards recommendations and away from requirements. Or if that's an unfair statement, at a minimum, it clearly is suggesting that there's an obligation on the requiring, the mandating employer that is not on the recommending employer. All right, so we've talked about so far EUA, and we've talked about what OSHA says, what the EEOC says, what the FDA has said. And when we move beyond EUA, then the question becomes, okay, if we were to require vaccination, what other limitations might apply? And we've already referenced on occasion the ADA, the Americans with Disabilities Act. It is possible that an employer would mandate a vaccination, but receive a inquiry from an employee who would claim that the vaccination is a contraindication for that individual, and that it, in effect, would qualify that employee to be disabled, or would in effect be a disability that would be protected under the ADA. A disabled person is defined as someone with a physical or mental impairment substantially limiting one or more major life activities of the individual, a record of such an impairment, or being regarded as having the impairment. And the EEOC has clearly indicated that that a reaction, somebody who believes they would suffer a contraindication from the vaccine, has reasonable evidence that would be true, that would qualify under this. And so if that happens, there comes an obligation to engage in a flexible and interactive process with this employee to determine whether an accommodation is required, or whether an accommodation would cause so-called undue hardship. Importantly, factoring into this is another rule that indicates employers do not have to provide a reasonable accommodations to employees who pose a, quote, direct threat to the health or safety of others. Now, let's talk about that next. So what is a direct threat? And the answer is that it is a significant risk of substantial harm to the health or safety that cannot be eliminated or reduced by a reasonable accommodation. So the ADA, according to the EEOC, does allow an employer to have a qualification standard that includes a requirement that an individual not pose a direct threat in the workplace. And certainly if we're going to be held responsible for that, there's got to be a commensurate, this has to be true as a commensurate matter. But what constitutes a direct threat, again, requires an individualized assessment. It's not enough for the employer to say, well, COVID-19 is a dangerous virus, and in all circumstances constitutes a direct threat to my employment, to my staff. Instead, you have to look at certainly reasonable medical judgment, the most current medical knowledge, best available objective evidence of the individual's present ability to perform safely the essential functions of the job. So what might that look like? Well, we would need to consider the duration of the risk that person who might be unvaccinated poses, the nature and severity of that harm, the potential harm, the likelihood that potential harm will occur, and then the imminence of that harm. And again, when we look at this and we say, okay, well, if this particular employee were not vaccinated, then this is the kind of threat that would be posed in the workplace to other employees, potentially to patrons. But we can't stop there. We have to go on and ask the question, okay, is there a reasonable accommodation that would neutralize the direct threat to the extent there is one? And in doing that, we have to assess whether alternatives are an undue hardship. For example, requiring that person henceforth to telework, or mask wearing, social distancing, the kinds of things that we've been doing for months now. If it's not possible to reduce that threat to an acceptable level using these alternatives, then EEOC guidance provides that an employee can be excluded from the workplace. But again, that doesn't automatically mean the person can be terminated. That depends again on whether it's an undue hardship for example, the person to telework instead of come into the workplace. This is going to be a individual by individual and company by company assessment. Again, it only arises in the context where somebody claims that being vaccinated would cause that person to be disabled. And so it's not going to be for certainly every employee who's going to be able to say this. There's going to have to be some reasonable evidence that that might be true. It's not going to be enough to just say it, for example. All right, so now earlier, remember that I said that the EEOC has made clear that if an employer merely asks for proof of vaccination, that is permitted. The mere asking for the proof is not a problem. But the EEOC goes on to say that there could still be a problem if, for example, asking why you go on to ask the question, well, why didn't you receive the vaccination? That kind of a question, open-ended, potentially implicates, elicits information about a disability that would be in fact protected. And oftentimes screening questions ask these kinds of questions. And before you get vaccinated, I'm sure you had to fill out a form that, advised the person who was doing the vaccinating about contraindications to the vaccine that you may have experienced. Those kinds of screening questions preceding vaccination are disability related and protected under the ADA. So if you are going to require the mandate, one thing to think about is, first off, that you may not want to do the vaccination yourself. Just requiring proof of it as opposed to the employer actually providing the vaccines and being forced to ask the screening questions, it just raises issues you don't otherwise have to deal with. The second thing to think about is that when you require proof of receipt of the vaccination, you may want to warn the employee not to provide any medical information as part of the proof in order to avoid implicating the ADA. And in this fashion, you can avoid crossing the ADA line. Okay, so we've talked again about EUA. We've talked about what the FDA says, what the EEOC says, what Osha says. We've talked about one rule that whenever, assuming for a moment EUA, we can get around that question and we can mandate the vaccine, we still are going to have to make sure that we comply with the ADA, meaning that if somebody has a contraindication to vaccination, we're going to have to go through the ADA accommodation analysis. The other possibility is that an employee comes forth and alleges that the vaccination would be a violation of its the individual's religious beliefs. And here, Title VII requires that the employer provide a reasonable accommodation for the religious belief, practice, or observance of the individual, unless it will pose, again, an undue hardship. And what's interesting here is that the undue hardship analysis is different than under the ADA. Under the ADA, undue hardship is defined, as I previously indicated. Here it is no more than a de minimis cost or burden is what constitutes an undue hardship. So no more than a de minimis cost or burden to satisfy the undue hardship analysis under Title VII, but the undue hardship analysis under the ADA requires a little bit more than that. And interestingly enough, just recently, the U.S. Supreme Court had the opportunity to revisit whether or not the undue hardship test would continue to be applied as it has been under Title VII. The court denied a petition for writ of certiorari in that case, where the plaintiff was essentially complaining that the undue burden standard is different under Title VII than it is under any other circumstance. Two justices agreed that they should have taken the case, but at present, the standard persists that undue burden under Title VII merely means de minimis cost or burden. Now, one other important point here is that religious belief is not the same thing as philosophical belief or strong or moral or ethical objections. And we know that there's a community of individuals who, not for religious reasons, but just for other reasons, believe strongly that any kind of vaccination is a bad thing and therefore avoid it. That kind of philosophical, moral, or ethical objection is not protected under Title VII as compared to actual religious belief under the Act. All right, so we talked about EUA, we talked about Title VII, religious accommodation, we've talked about the ADA. We come now to the Genetic Information Non-Discrimination Act, or GINA, and the bottom line for this act is that according to the EEOC, GINA is not typically an obstacle to mandating vaccination. GINA does not prohibit employers from asking employees whether they've had contact with anyone diagnosed with the disease, administering the vaccination to employees or requiring employees to provide proof that they've received the vaccination does not implicate GINA either, because it does not involve the use of genetic information to make employment decisions. However, the EOC goes on to say, again, that there is a line here that could be crossed. Employers may not use genetic information to make decisions relating to terms, conditions of employment. GINA does preclude employers from asking employees medical questions about family members, as may be typical in, again, a pre-screening questionnaire. So another reason for employers not themselves to do the vaccination, the pre-screening questionnaire not only potentially implicates the ADA, but also potentially implicates GINA. And then once you have information about the vaccination, employers need to be careful about what they do with that information. Redisclosure could be a violation of GINA. Another set of laws that become relevant besides the federal statutory anti-discrimination laws, the ADA, Osha, Title VII, GINA, we also need to think about what our contracts say. Most employees are not contract employees. Most of them are probably, for most employers, at-will employees. But for some employees, they are contract employees. For example, typically teachers are contract employees, maybe managerial staff sometimes will have contracts. In any event, if you have a contract with an employee or an independent contractor, or for example, a union, if you have a unionized workplace and so you're subject to collective bargaining, in those circumstances, whether you can require vaccination may be a contractual matter, and you will need to look at, you know, what your contract says. You may not be able to mandate vaccine without amending the contract, which of course would require you to provide additional consideration for the amendment. And if you're going to change what unionized workplace requires, that's probably a collective bargaining matter. And I've also pointed out on this slide that to the extent you are a government contractor, there are, of course, separate federal laws that are implicated in that event, and that could be the subject matter for a whole separate presentation we won't get into at length here. But suffice it to say, if you're a government contractor, there's a whole other set of rules that we may need to be concerned about. And of course, even if you don't have a contract, sometimes you can create expectations, reliance kinds of expectations that can be enforced under so-called quasi-contract law or as a result of promissory estoppel. So if you've made representations in the past that could be implicated by a mandate, you would need to make sure that those representations are not contrary to your actions with respect to the mandate. Okay, so with respect to employees, confidential information also is something we need to be concerned about. Immunization records may very well be protected health information. They're certainly medical records. And as a result, when an employer comes into possession of these kinds of records, we need to keep them confidentially. The EEOC requires that all medical information about employees be stored separately from the employee's personnel file. Most employers are not covered entities within the meaning of HIPAA, with the exception that certainly healthcare employers commonly are, health plans are, healthcare clearinghouses are. There are actually other circumstances where HIPAA could become pertinent and relevant to a private employer. If you're concerned about that, that's an analysis that certainly you should engage in with counsel to go through the nuances of that. Certainly, if you are going to seek directly from a healthcare provider information about vaccination, you will not be able to get that information from the healthcare provider, or you should not be able to, without employee consent, because that healthcare provider will be protected, will be subject to HIPAA. Of course, besides federal law, when it comes to confidential information, just state law and district law is also going to be pertinent. And also, district and state law typically has its own anti-discrimination requirements, and certainly workers' compensation can be material to injuries in the workplace, including alleged injuries relating to vaccination. So on the screen now are the District of Columbia, Virginia, and Maryland anti-discrimination provisions, all of which, depending on where your business is located in the DC metro area, larger, greater DC area, could be implicated just like federal law. And then specifically in DC, I just took a look at, well, what could be the privacy-related implications of disclosing confidential information. And the answer is that under common law, the District of Columbia recognizes 4 common law invasion of privacy claims. You don't want to be subject to any of those. And then specifically, the Protecting Business and Workers from COVID-19 Emergency Amendment Act, it permits employers to establish policies that require employees to report COVID-19 testing, provided the employer does not further disclose the information, except to the Department of Health or other agencies. So again, confidentiality is important under federal as well as state, and in some cases, even local law. That's beyond the scope of today's presentation. All right, we've been talking all of this time about employees. Some of you want to know about clients and or so-called patrons or customers. And here we have a slightly different regime that's applicable, and it is still the ADA, but it is a different title of the ADA, Title III, that concerns places of public accommodation. And an operator of a place of public accommodation has this obligation not to treat differently disabled individuals. Now, again, there's a public accommodation requirement that comes along with Title III to reasonably accommodate disabled individuals, but it's subject to, again, a direct threat limitation and a separate limitation specific to public accommodation law known as the fundamental alteration rule. To the extent somebody seeks an accommodation that would cause a modification so significant that it alters the nature of goods, services, facilities, privileges, advantages, or accommodations offered, that is not a reasonable accommodation that needs to be made. The U.S. Supreme Court gave a little bit of meat to this in a case involving golfing a few years ago, where there was a PGA participant who wanted to not walk the golf course and instead ride a golf cart. The PGA took the position that walking was a fundamental aspect of the game of golf. The plaintiff said, no, it's not. I should be able to just, be in my cart. And out of that case came the idea that what a fundamental alteration really means is something that changes the rules of the game, and not any other lesser modification. Well, so what's a place of public accommodation? It's what you might typically think of. Of course, public accommodation law came out of the civil rights movement of the 60s. It pertains to inns, hotels, motels, restaurants, retail establishments, places of entertainment. This is just an example list. It's not a comprehensive one, but just to give you a flavor of what kinds of places of accommodation might be subject to it. Besides federal law, again, we have to look at state law. The states also typically prohibit unlawful discriminatory practices when it comes to places of public accommodations on the basis of disability and other protected classifications not subject of today's presentation. Virginia does likewise, Maryland does likewise. And then this isn't specifically relevant to businesses in the district unless the businesses have operations in other states. But you may know now that there are 3 states that ban so-called vaccine mandates for patrons, that so-called passports. Florida, Texas, Utah now prohibit it either as a matter of executive or legislative law. Just to be aware of that in the event you have operations in those states. All right, we come to near the end of our presentation. We're coming to immunities. We're not going to spend a whole lot of time here, but suffice it to say that there have developed some immunities in the law for organizations involved in the administration of the vaccine. And these would certainly potentially be healthcare workers, but they also could be locations, even your business. If you're providing a space in your parking lot for, for a vaccination site, you could be a covered person. If you are, there are some substantial federal immunities against claims associated with the administration of the vaccine. Here's a definition of who might be covered persons. Again, manufacturers will always fall into that. But you see there that if you supervise or administer the administration of a site or the distribution or provision or use of a vaccine, those are also potentially qualified. And then the states also have statutes that protect, that provide immunities for individuals involved in the vaccination effort. Again, most of the immunities protect predominantly healthcare providers, but depending upon the state, they also may protect places of vaccination, donors involved with the vaccination effort, and volunteers. I took a brief look at the District of Columbia, and you'll see here that the relevant statute protects healthcare providers, donors of time, professional services, equipment, or supplies for the benefit of persons or entities providing care for COVID-19 patients, and then some contractors and others. In Virginia, we have two provisions at issue. And again, it's focused predominantly on healthcare providers. And then in Maryland, again, healthcare providers protected. There was a bill that, as far as I can tell, appears to have died. It would have protected persons who act in compliance with certain statutes, rules, and regulations in connection with the COVID-19 vaccination effort or other COVID-19 issues. I think it looked like that SB 210, there was an adjournment without passage. All right, so we've talked all along here now about mandates. We've looked at the EUA. We discovered that there's some possibility that it could be interpreted as precluding mandates. We've talked about if that's not true, what are the remaining limitations? And we learned that that as far as Osha is concerned, if you mandate, you've got to report it if your employee has an adverse reaction. We've learned that the ADA requires us to provide reasonable accommodation to a person who might be disabled or suffer contraindications from the vaccine. And we've learned that there's a religious Title VII exemption, besides potential contractual limitations, and then of course the ongoing requirement that we keep information confidential. That was all for employees. And here, the question becomes, okay, well, besides mandates, what else could we think about doing? And of course, one answer is that we could incentivize employees rather than mandate employees to become vaccinated. And if we did that by giving them time off for vaccination, providing the vaccine at work, covering the cost of vaccination, I favor that over providing it at work, promoting the vaccine and vaccination sites. If you remember from the beginning of the presentation, the letter from the mayor suggested exactly this, through a company-wide messaging, maybe an educational program. Incentives are not a problem. Now, there are some kinds of incentives that potentially could be an issue. One of those is offering monetary bonuses or special recognition payments to employees who become vaccinated. The least controversial way of doing this would be to do so in connection with employees who participate in general in a wellness program for which vaccination is one qualifier. That would probably be the least risky version of this. But whenever you provide unequal treatment to individuals, some of whom could be protected classifications like the disabled, you need to be aware that there's still a risk. It's not as substantial a risk, but still a risk when you consider monetary bonuses. And then, of course, the other thing you could give thought to, and this is really actually somewhat required, and that when we go back to the direct threat analysis, remember, we said that to the extent an employee would pose a direct threat to the health, welfare, safety of others, actually to himself as well, then the employer may, that may be a reason for the employer to require vaccination. That direct threat requirement is certainly more substantial in the context of high risk staff members or patrons. And so if you have certain employees that fall into that category, ones who are serving high risk clients, again, you might, another way to think about this is say, okay, well, we're going to mandate for some and not for others. And again, you would only want to do that if the direct threat analysis supports it. One more important point here is that direct threat analysis is not a binary one. You cannot do it at time 1 and repeat it at time 2 necessarily, because we know that the direct threat is changing over time. Certainly, the more people get vaccinated in your workplace, the less direct threat any individual who is not vaccinated poses to those staff. On the other hand, that person who is not vaccinated may still pose a significant risk to unvaccinated clients. But here again, even the clients in increasing numbers are becoming vaccinated. So this is not a stationary analysis that you must conduct. It's an iterative one that is evolving even as time goes on. And certainly once the CDC were to determine, if it ever did in the near future, that the threat is not what it states currently on its website, that would be a major impactor with respect to your ability to mandate the vaccine. That was for employees. Now we think at last, and we'll take questions after this, about patrons. For patrons, remember what we've learned so far is that the ADA protects patrons against discrimination to the extent you operate a place of public accommodation. And you are required, therefore, to provide a reasonable accommodation for those individuals who are disabled. So what alternative might there be to mandating that those customers be vaccinated so as not to have to deal with those protocols? And of course, the first answer is that you could require a negative COVID test as an alternative to vaccination. Now, if you have those two choices, it's really no longer a mandate. unless for some reason a patron can't do either because of a contraindication to both. I think that would be a highly unusual case. It's conceivable, but by requiring proof of a negative COVID test within 3 days or something like that of some significant service that you might offer, that might be a way to provide an alternative to vaccination that would get you out of the pure mandate world. You could, for patrons who are vaccinated, expedite services. You could give them priority access to services. You could provide them with product or service awards. I think several retailers are providing freebies to people who are vaccinated. And then you could provide premium service or preferred to preferred vaccinated patrons. So you could treat them better in some circumstances without implicating as many of these issues. And again, that has limits too, because whenever we treat disabled persons differently from other persons, there's got to be a good reason for it. But in these cases, the risks of this kind of practice are much, much less. And in particular, requiring the negative COVID test as an alternative to vaccination, I think that's a fairly safe avenue to proceed down. Not without risk, companies may offer services not available to other patrons. If you want to offer some services to persons who are vaccinated, they can come on site, but the other patrons cannot, for example. That's one possibility. And then again, distinguishing between your highest risk patrons and your lower risk patrons, that's another reasonable step you might want to consider. Still not without some risks. All right, so we've spent, got I think 8-10 minutes left for questions, and I'll ask if I can answer any of those at this point.
Yep, so we have some questions, not too many because you were quite thorough. First, and what everyone just wants to be clear about, in DC or Maryland or Virginia, so long as it does not violate the Americans with Disabilities Act or any other anti-discrimination law, a business can deny access to a non-vaccinated customer. Is that correct?
So the question is, if we are compliant with the ADA and you want to deny a customer access who has not been vaccinated, is there a law against that? And I think that the answer is that there is not a law against that. But of course, the critical thing there is compliance with the ADA, which means that you've got to be willing to treat persons who have contraindications differently and make exceptions, or not exceptions, but reasonably accommodate those individuals. That's the key limitation under federal and state law.
And would it also be important here, for a business or nonprofit to uniformly apply the mandate? Of course, with exceptions as required under law. So for example, they couldn't say, oh, this customer isn't vaccinated, they can come in. Oh, but this other one, they have no vaccine and you aren't allowed in.
Okay, and so we're still talking only about patrons and not employees at this point, I assume. And
yes.
Well, uniformly is exactly what the ADA doesn't allow, right? So again, as a matter of ADA law, you've got to be able to provide a reasonable accommodation when appropriate to persons who are disabled. So it is uniformity that the ADA Title III blows up. Now, I understand sort of the theory behind that, which is, boy, how can we justify letting one person in and not another person? And of course, that's the trick here. I mean, that's the whole enchilada as to where the challenges are with respect to mandating for customers.
Great. If an organization decides that they are really serious about this, they understand the implications, and they want to move forward with requiring employee vaccination or patron vaccination, then legally would they be required to require vaccinations for the other parties as well? So, employees have to be vaccinated, now customers do too. Or if customers have to be vaccinated, employees do too.
Yeah, it's an interesting question, and it goes to the direct threat analysis, right? And let me spin that out. So if you required patrons to be vaccinated, but you did not require your staff, you can see that your argument that the patrons pose a direct threat is reduced, right? In other words, if the concern is anybody who is unvaccinated is potentially going to transfer the vaccine, that certainly is true as much for employees as it is true for customers. So it does, as a general matter, depending upon your direct threat analysis. In other words, you got to go back to the beginning of this, which is to determine, well, what is the cause for your seeking the vaccination? Losing my voice, I apologize. What's the cause for the vaccination? And if the answer is a cause that is equally pertinent to the employee and to the patron, then treating them differently is not going to be reasonable. It is going to go, when you do get the challenge from the person who you're requiring mandating the vaccine from, and your response is, well, we only require it for one of the two groups, even though both of the groups are pertinent to the threat, your ability to defend that action is going to be that much reduced.
We all know, and I think, in the legal profession, we recognize the fact that it's easier to prove the presence of something than the absence of something. But on that premise, could an employer say that they do not permit their employees to be vaccinated against COVID-19?
Okay, so this is the opposite inquiry. So you want and there's, I think, a case out there, actually in Florida right now, involving a school where the school has affirmatively stated that you cannot work here if you are going to be vaccinated. Is that a lawful decision? Well, you have to go back through the analysis. Certainly, it's consistent with the EUA because you're not putting the person to the test of having to be vaccinated. Could there be an individual who works for that employer who, because of a disability, argues that without other staff or patrons being vaccinated, that they're going to be negatively impacted to the point where they could state a claim under the ADA? I think that's at least conceivable. But as a general matter, I think that probably you're on safer ground than certainly mandating the vaccine, because EUA doesn't apply in that circumstance. Certainly Title VII isn't going to be an issue in that circumstance. OSHA's already said that it's only the mandate that requires the reporting. So you funnel it down, and then there's a contract question, and finally, with respect to OSHA, the only real question becomes, can you still have a safe workplace in that event? And remember, one of the slides at the beginning of the presentation was OSHA telling employees, if you believe that the actions of the employer are making it unsafe for you to work there, you can complain. Certainly, there would be the possibility that there would be a whistleblower who would argue that the employer is not taking the necessary steps to protect, make sure that the general duty clause is being met. So I think that if the employer was going to do what you've suggested and preclude any vaccination, certainly at a minimum, that employer would need to comply with that general duty clause in other ways and be able to establish that in the event of a whistleblower complaint.
Okay, great. And with that, it looks like we are already out of time. The clock just switched to 1 o'clock, and we do want to be respectful of your time, Nate, and our listeners. I want to thank you again, and I want to thank our listeners for joining us. We are going to send a survey to everybody that logged in today. So please share your thoughts on this webinar there and any topics that you're interested in for the future. You'll also get access to a recording of today's program if there's anything you want to re-listen to, or you thought it was so fantastic that you're going to share it with other small businesses and nonprofits in your circle. And remember, if you'd like to talk one-on-one with an attorney about legal questions related to your organization, view the Pro Bono Center's upcoming events, our online resource library, and more, you can visit us at lawhelp.org/DC/NPSB, Nonprofit and Small Business, NPSB. And with that, thank you so much again, Nate, and to Holland Knight. This was fantastic, packed full of information, and we truly appreciate your time.
That's my pleasure. And if anybody wants to follow up with me separately, happy to entertain those questions as well. Have a great afternoon, everybody. Thank you.